Hello everyone, welcome to Medical Education Nepal. Today we will discuss about the legal procedure. Okay, so first of all, what are the objectives of this session? What we are going to discuss today is given over here. We'll discuss about the inquest, Chalan, which is more important. Then we'll discuss about the evidence, the dying declaration and deposition, Compos Mentis and some medical terms, offences, warrant, and these all things. The main thing is we will discuss also the past year Dhaka University questions and we will try to solve each of them. Now, what is inquest? So, first of all, look at these three photos. In the first photo, we can see there's some kind of inquiry is going on, legal inquiry. In the second photo, we can see there is some kind of investigations, and in the third photo, we have seen a dead body, and we will find out the cause of the death. So basically, inquest is a legal inquiry or investigation into the cause of death when the death is sudden, suspicious, or unnatural. Okay. Now, what are the types of inquest? There is police inquest, magistrate inquest, coroner's inquest, medical examination system, procurator, fiscal, continental system. Okay. Now, police inquest. We can see over here photos of police officers in India. The police inquest it is done by the police officer. The main thing is it is done by a police officer who is not below the rank of sub inspector. Now, the magistrate inquest. It is done in case of death in prison, under police custody, under police interrogation, police firing, and exhumation. Exhumation means the digging out of the dead body from the grave, and also the post-mortem examination, and when a person loses his faith in the police inquest. Coroner's inquest. Here, a medical practitioner or a lawyer with the rank of the first class magistrate is appointed by the government as coroner, and this coroner he conducts inquest in all the unnatural and suspicious deaths. He also has got some judicial power, like he can summon a doctor to give evidence in the court, and this system is followed in the United Kingdom, Nepal, Pakistan, and Sri Lanka. It is not followed in case of Bangladesh and India. Now, medical examiner system. Here, a medical practitioner, also known as the medical examiner, is appointed as a coroner, and he has got no judicial power, and is followed in most of the states of the United States of America and Japan and Canada, and it is not followed in case of Nepal, Bangladesh, or India. Now, Chalan. What is a Chalan? Basically, it is a requisition. The word requisition means either a request or demand or order from a legal authority in a prescribed or tabulated form to an authorized government doctor to perform the post-mortem examination of a dead body. The Chalan number in case of Bangladesh it is 5371. Now, what is the difference between an inquest report and Chalan? The inquest report it is written in plain white paper, whereas the Chalan it is written in the prescribed or tabulated form. In inquest report there is a brief history of the case, whereas in Chalan there is no history. In case of inquest report there is a description of the injuries that are found in the dead bodies, whereas in case of Chalan there is no description, and the signature of witness is present in inquest report and absent in or not required in case of Chalan. So now moving forward to evidence or deposition or testimony. For Chalan and inquest report, I hope you guys have seen this during the autopsy, how these are prepared. Okay, so evidence, deposition, or testimony. It is the statement of a witness under oath. It is also defined as a document for the inspection of the court, and also defined as all the legal matters that helps to prove or disprove any matter of fact. Now, medical evidence. In medical evidence, the types are the documentary evidence and the oral evidence. Now, the documentary evidence, there is medical certificate, medical legal reports, and dying declaration. These are the types of documentary evidence. And in the oral evidence, there is direct, indirect, or hearsay. Now, documentary evidence. Documentary evidence, as I have told, it is classified in three categories: medical certificate, medical legal reports, and dying declaration. Now, some of the examples of the medical certificates are the birth certificate, death certificates, sickness certificates, and fitness certificates. And the medical legal reports are the post-mortem examination report, victim examination report, age certificate, and injury certificate. Now, moving forward to oral evidence, there is direct, indirect, and hearsay. Direct means suppose the person A saw person B murdering C. So, in this case, the person A is giving evidence. This is called directly. We have seen the person B murdering C. So, this is known as the direct oral evidence. In indirect, the person A saw B with a knife on the day and the place of a murder, but he haven't seen him murdering the person C. So in this case, this is known as the indirect oral evidence. And he told me this is same thing is illustrated in this photo. You can see over here. Okay, and hearsay means suppose someone said to someone uh, I have seen this person murdering this one, and this information goes into the court by a person, and he says in the court like another person told me that he have seen another person murdering. So this is known as the hearsay thing. Now, difference is between the dying declaration and dying deposition. So first of all, the definition. Dying declaration, it is a statement, either written or oral, of a person who is dying as a result of some unlawful act in relation to the cause of his death. Whereas the dying deposition, it is defined as a statement of a person on oath that is recorded by the magistrate in the presence of the accused or his lawyer, who is allowed to cross-examine the witness. In case of dying declaration, the magistrate, police officer, or doctor can take, whereas in case of dying deposition, only the magistrate is allowed to take. In case of dying declaration, oath is not required as the person is dying, whereas in dying deposition, the oath is required. So now the value in the court is less for dying declaration as there is no oath, and whereas for dying deposition it's more because of the oath and the magistrate is only allowed to take. And the dying deposition, also known as bedside court, and is not followed in India or Bangladesh. Now, what is compos mentis? It means the found state of a person. Its importance is asked in the viva. Doctors have to present during the dying declaration for the compos mentis of a person. Means like when a person is dying, to check his mental state, whether he is in a sound state or not, or he is insane. So this is required, and this is the importance of the compos mentis. Now, some of the medical terms. Affidavit is written declaration under oath. Oath is a religious asseveration of a witness calling God before giving evidence standing in the witness box. Plaintiff means the complaining person is called plaintiff. Defendant is the accused person is called defendant in case of criminal case. And respondent, the person against whom an appeal is filed, is called respondent in case of civil case. Open verdict means the announcement of commission of crime without naming of the criminal. It means like I don't. Someone has committed a crime with me, and I don't know the name. Someone not for suppose a group of person has committed, but I don't know their name. So I have like went into the police station and have like given my statement, and it is like the open verdict. I have given the announcement of the commission of the crime. Crime has been committed without naming of the criminals. Now, what is offense? Any act or omission that is made punishable by any law is known as offense. Offense is of two types: cognizable and non-cognizable offenses. Cognizable offenses means the type of offense in which a police officer can arrest a person without warrant from the court or magistrate. It's called as cognizable offense. For example, in rape cases, murder cases. And the non-cognizable offense, just opposite, the police officer cannot arrest without any warrant. And examples are assault cases. Now, what is a warrant? It is a written order for the arrest of a person or the forceful production of a person in the court as witness. Now, warrant cases is a case that is relating to an offense which is punishable to death or imprisonment for greater than 2 years term. And summon cases are the all other cases except warrant cases, or we can say a case that is relating to an offense which is punishable to imprisonment for 1 year or less than 1 year is known as summon cases. Now, what are the punishment given by the law are the death, imprisonment is either simple or rigorous, with the hard labor and solitary confinement, then imprisonment for life, then there is a fine, forfeiture of the property, warning, and the death sentence is also known as the capital punishment. Some of the methods are the judicial hanging, electrocution, lethal injection by giving the sodium thiosulfate intravenously, gas chamber, and garroting. Now, what is subpoena or summon? Subpoena is made of two words, sub and peona. Sub means under and peon means penalty. So it is defined as it is a court order that is signed by a judge or other officials compelling the attendance of a witness in a court of law under penalty on a particular day, time, and place for the purpose of giving evidence. If a person fails to attend the court in case of a civil case, then he will be liable to pay damages. And if a person fails to attend the court in case of criminal case, then the warrant will be issued against him. Now, the types of summons are summons subpoena adestificandum, subpoena ducis dictum. Witness have to appear physically before the court to give evidence in case of adestificandum, and ducis dictum, witness can submit a document in the court. Now, what is conduct money? It is the fee that is offered or paid to a witness in civil cases at the time of serving the summons to meet the expenses for attending the court. Now, who is a witness? A witness is a person who gives evidence in the court of law. Now, the types of witness are common witness, expert witness, and hostile witness. Okay, hostile witness doesn't come in the types. The types of witness are common witness and expert witness. Now, the hostile witness is a person who is supposed to have some interest or motive for concealing a part of truth or giving completely false evidence is known as hostile witness. Before taking oath, the court will declare a witness as hostile on the suggestion of prosecution lawyer. This question is asked in the viva on the suggestion of which lawyer the court will declare a witness as a hostile. Then it is the prosecution lawyer. Now, perjury means giving willful false evidence under oath. Now, how a doctor can give evidence in the court? He can give as a common witness, as a medical practitioner, as an expert witness. And now, what is the procedure of giving evidence in the court? First of all, there is receiving a summon or warrant, attendance in the court, taking oath. Then there is a deposition. In the deposition, there is direct examination, cross examination, and again re-examination, and then there is a question by the judge. And at last, there will be release of witness from the court. Now we will look at the court. Court is of three types: civil court, criminal court, and both civil and criminal courts. In the criminal court, it is further of two types: session court and magistrate court. Magistrate court is again of further two types. Further four types: judicial magistrate, metropolitan magistrate, additional district magistrate, and executive magistrate. Executive magistrate example is the mobile court. We also have to learn the different examples of the civil court, session court. These are asked in the viva. Now, metropolitan magistrate court is for the three types: chief metropolitan, additional chief metropolitan, and metropolitan magistrate. In case of both civil and criminal court, there is Supreme Court, which has got two branches, two divisions: appellate court, and high court. Or we can say appellate division and high court division. And then another is the district and session judge court, additional district and session judge court, joint district and senior assistant judge court. Now, what is court? It is an institution where laws are to be executed. Now, what are the powers of different courts? The power of Supreme Court is it can judge any case, it can pass any verdict, and it can declare any ruling. Now, what is the power of district session judge? It can judge any criminal case, it can pass any sentence which is authorized by the law, but this sentence must be approved by the High Court Division of Supreme Court. These are asked in the viva that Okay, this decision judge can give the death sentence, but it must be approved by which court? So it must be approved by the High Court Division of the Supreme Court. Power of senior assistant session judge: can judge any criminal case, can give imprisonment up to 10 years and fine, and cannot pass death sentence. Now, Metropolitan Magistrate is imprisonment up to 10 years and fine. Other courts are the Human and Child Abuse Court, Quick Trial Court, Special Court, Mobile Court. Okay, now moving forward to the questions, we can see defined court, classify court, judicial system. Same question. The court, different types of court: court of Bangladesh, courts of Bangladesh, criminal courts of Bangladesh, sentence authorized by the law in criminal cases, sentence authorized by the law in criminal. Okay, there's sentences like the punishments. Okay, the death sentence, imprisonment, forfeiture of the property, fine, warning, these all. Okay, and what punishment must be given by assessing the same thing, what is cognizable and non-cognizable offenses. So these are the things for the courts. Now, inquest and Chalan. Define inquest. What are the parts of inquest? What are the conditions? What the magistrate? Okay, for inquest report. For inquest, what are the parts of the inquest? Okay, the parts of the inquest are, we can find the particulars of the victim, the name is, sex, religion, and the description of the body, where the dead body was found, the position, its surroundings, the opinion of the witness, the opinion of the police officer, the signature of the witness, the signature of the police officer. These are all things that are given in the book, in the guidebook, or also in the main book. You can see from there. Now, what are the conditions when magistrate inquest is mandatory? Okay, so these are the when there is the death in the police custody, during police interrogation, or during police firing, when there is a death in prison, when there is a death in psychiatric hospital, or exhumation. These are all given in the previous slides. Now, what are the medical legal examinations done in our country, or what are the different types of inquest that is prevalent in Bangladesh? So this is the same question. There is a police inquest and magistrate inquest is done in case of Bangladesh. Now, when magistrate inquest is required, same. What are the conditions when police inquest is not valid? Okay, if it is done by a police officer who is below the rank of a sub inspector, it will not be valid. Then, if there is some kind of foul play is done, then it is invalid. And there are other things also, but this is not that much important questions. If you guys want to know, I will definitely search more reasons for what are the conditions, and I will give you all. Then, inquest report, inquest sim, witness, define witness, types of witness, paint picture. What is the paint picture of an ideal medical witness? Now, the paint picture of an ideal medical witness is like, what is the criteria of an ideal witness? Like, he should be mentally sound, he should attend the court with confidence, then he should not avoid any questions, he should answer by understanding the question. These are all things are given in ready also, and also in the guide. You can see from there. Is hostile witness: who can declare a witness hostile? Obviously, the court will declare a witness hostile uh, on the suggestion of prosecution lawyer. Okay, so what is gained by such declaration? We can obviously, for we for this no, sorry, for this hostile declaration, we will obviously avoid the court of the fake evidences. Now, what is the difference between hostile witness and perjury? Okay, it is given the previous slides. What is perjury? It's also covered. Uh, Now, what is the evidence? Medical documentary evidence, types of steps of parts of deposition. What are the parts of deposition? What are the procedure of deposition is also given in the previous slide. Conduct money, procedure, declaration, short notes. Okay, circumstantial evidence. Now, What do you mean by circumstantial evidence? It is also known as the indirect evidence. We have given learned in the previous slide in the oral evidence, direct, indirect, and hearsay. So it is also known as the indirect evidence. So basically, these are all things related to the second item, legal procedures. I hope you guys liked the video. Thank you.